Good evening and welcome. This is the July 13th, 2022 public hearing of the Land Use Commission. The City Code directs this body to hear applications for map and text amendments, special uses including planned developments, zoning relief, and appeals from decisions of the zoning administrator, as well as to make recommendations regarding the city's long-term planning goals and objectives. Depending on the type of matter, this commission will either make a final determination or send its recommendation to City Council. Ms. Jones, would you please call the roll?
Commissioner Aravallo. Commissioner Halleck.
Here.
Commissioner Cullen. Commissioner Westerberg.
Here.
Commissioner MIRINTCHEV.
Here.
Commissioner Johnson.
Here.
Commissioner Lindwall.
Here.
Commissioner Hugo. Commissioner Pactel. And Chair Rogers.
Here. With 6 members present, we do have a quorum. Also present tonight from city staff are Neighborhood and Land Use Planner Megan Jones, Zoning Administrator Melissa Klotz, Assistant City Attorney Brian George, and we'd like to welcome Planning Manager Liz Williams, who's joining us for the first time this evening. And I'm going to ask her to introduce herself just briefly here in the middle of my little intro.
Thank you, Chair. Good evening, everyone. My name is Liz Williams. I've been with the city now for a total of 3 days. I come most recently from Washington State. I worked for Kitsap County as their planning supervisor, overseeing long-range planning and code development. I chaired the county's planning commission and also was involved in several amendments to their comprehensive plan and code projects focused on helping to remove barriers to investment within our urban areas. Prior to that, I worked in Wisconsin for the city of Oshkosh as a senior planner. Most of my work there focused on neighborhood revitalization and all development review activities. I also, during that time, was involved with leading a downtown reinvestment strategy update for our central city and did several sub-area plans in addition to a comprehensive plan update process as well. So really excited to be here. Look forward to working with you all in the coming months and appreciate the opportunity to share a little bit about myself. So thank you.
Ms. Williams. I'm going to sort of intervene in my normal little intro speech here because we do have a case that I have the feeling some people are here for, which is the 2044 Wesley Avenue 22 PLMD 0010. And that the applicant has requested a continuance on that matter, so we will not be hearing that this evening. So if you're here to speak on 2044 Wesley, we will not be hearing that this evening. Do we have a date that they've been put back on the schedule?
That date would actually be in September. Hold on a second. It would be the second meeting in
Just a moment.
September.
Which is what date?
That would be the 28th.
So it'll be continued till September 28th. Yes, ma'am. Sir, sorry.
I'm concerned, are they gonna make a presentation to the developer that the community can have access to before this variance?
That's,
Or is this a done deal? Are they gonna show concept of the townhouses, 12 units, how they involve the appropriate land use as a developer by any kind of information visible and we as members of the public can actually look at and analyze and ask questions about it? Could they approve it?
Ms. Klotz.
I'll jump in. There are preliminary plans posted on the city website under large-scale development plans. That does show what the current proposal is. My understanding is that it will be changing. That's why there has been the continuance request. So when we receive new information, we will put it up on the website for viewing.
So yeah, so we will not be hearing that this evening. So again, if you are here for 2044 Wesley, that case will not be heard tonight. It's been continued until September 28th. Thank you. I didn't want you to have to sit through my long speech here at the beginning to find that out. So with that, I will continue on. This is a formal hearing, and there are rules that govern our proceedings. Most importantly, only one person speaks at a time, so all testimony may be accurately recorded. Anyone who wishes to address the commission regarding any matter on tonight's agenda will have the opportunity to do so at the appropriate time. If there are a large number of persons signed up to comment, our rules grant the chair the right to limit the amount of time for each person to speak. Commissioners may ask questions of persons at any time. Our procedure is to hear from staff on the documents on file and then receive testimony and other evidence from the applicant or appellant. After that, persons wishing to make a statement regarding the matter will have a chance to do so. Any person with a legal interest in property located within defined notification requirements of the subject property may present evidence, reasonably question witnesses, or seek a continuance of the hearing. When all supporting and opposing testimony and statements have been heard, the applicant or appellant will be given the opportunity for rebuttal or a closing statement. Then the commission will close the record and begin deliberations to consider the standards. The commission will make a formal finding of fact based on the testimony and evidence presented, guided by the standards, the commissioner's knowledge of our community, and the recommendations of staff. All testimony is taken under oath. Although we do not apply the strict rules of evidence, please limit your testimony to the proposal as it relates to the standards contained in the zoning ordinance and corresponding staff memorandum. When testifying, state your name and address for the record, and please sign in on the public comment sheet. Our meetings are audio and video recorded. Please make sure that you are at a microphone when asking questions or making statements so that you can be properly recorded. All proceedings are subject to broadcast later. Any matter not concluded at tonight's hearing will be continued to our next regularly scheduled meeting. We do have 3 items on the agenda this evening. The first one is a map amendment, which is 22 PLND 0038, which has been continued from our June 22nd meeting. The other item is a text amendment regarding billboards, 22 PLND 0042, and the final one, 2044 Wesley Avenue, 22 PLND 0010, as I mentioned, has been continued till September 28th. So we really only will be hearing the 2 tonight, the first of which is a continuance from our last meeting. The first item of business that we do have, though, is the approval of our minutes from June 22nd. Has everyone had an opportunity to look through those, and are there any edits or comments?
I have some.
Commissioner Halleck?
I normally don't have edits, but these are all edits to statements that I made, and some are very minor, so I apologize if I'm wordsmithing. But on page 4, the third paragraph from the bottom of page 4, starting with Commissioner Halleck stated, the formula used for the initial TOD requirements is likely irrelevant, so additional consideration, instead of should be done, it is appropriate, I think, is the better way to say that. And then I have a few here. And then on page 8, let's see, let me go down to page 8. Hold on. Page 8, paragraph 3, again, my statement. Hold on. This first sentence didn't make sense to me. Commissioner Halleck stated that this is one subject that has not been addressed. Notice was provided for this about a month or so ago. I'm not sure what that means. I think what I said was that the subject has been brought up before to this commission, several times before to this commission. So that might be clearer than that. And then the last sentence in that same paragraph says, staff has explained why this change is needed, and the neighbors have explained why it is not needed. And then it says, with regards to the continuance, and there's nothing more than that. So I think with regard to the continuance should be deleted, because it's not a sentence. I don't know where I was going. And then on page 10, this is my last one. On page 10, excuse me, let's see. Second paragraph, again, my statement. It wasn't clear to me. It says Mr. Marlis stated that with the 12/13ths, or I think it meant to say 12 or 13 existing locations. I don't think there were 12 or 13 that were mentioned, but I think it's more appropriate to say, rather than 1213/13, say, let's see, where was that? Refer to the other existing locations operated by Kensington instead of just the 1213ths. That just would be clear for the record, I think.
All right.
Okay, that's it.
Other comments, questions, edits? If not, is there a motion for approval of the minutes from June 22nd?
I move approval of the June 22nd minutes.
Moved by Lindwall. Is there a second?
I'll second.
Seconded by Westerberg. Is there any further discussion? Hearing none. Would you call the roll, please?
Commissioner Halleck? Yes. Commissioner Westerberg?
Yes.
Commissioner MIRINTCHEV?
Yes.
Commissioner Johnson? Yes. Commissioner Lindwall?
Yes.
And Chair Rogers?
Yes. So that is 6 votes in favor, none opposed, so the the minutes are approved. With that, we will move into the first item, which is an item of old business, which is a map amendment regarding a map amendment 22 PLND 0038. This is a city-initiated map amendment that was continued at our last hearing. Ms. Lutz had asked for a continuance, and so I'll begin with her. She's on my sign-up sheet. Is there anybody who did not have an opportunity to sign up before I took the sign-up sheet away? Not seeing anyone. Ms. Lutz, if you'd like to come up to the lectern, please. And if you could just state your name and address for the record and remind you that you are still under oath.
Yes. My name is Megan Lutz, and I live at 2637 Crawford.
Thank you. And so you did not make a statement last time, so you are now able to make a statement for us.
Okay, thank you. Our home is one property away from 3 of the parcels that are being considered, excuse me, for removal from the Central Street Overlay District. Thank you for allowing the continuance so there could be enough time to make affected property owners aware of their right to formally protest this change. A group of neighbors collected 171 signatures, and the city clerk has actually, just as of today, asked for more time to certify the list due to the number of signatures. The volume of submissions shows that there's widespread neighborhood opposition to this proposal. Despite what was said at the last hearing on this proposal, Councilmember Suffredin does not support this zoning change. He sent a letter to staff on June 26 requesting that they withdraw this proposal, but apparently staff was unable to do that. I didn't see the letter in the packet. I'm not sure it was forwarded to you, but I have copies I can give you at the end if you need it. At the last meeting, you heard from Jeff Smith, president of Central Street Neighbors Association. He was involved in the Central Street Master Plan process. He testified that the inclusion of these properties in the overlay district was intentional, and the goal was to use planning and zoning to make the dangerous intersection safer for cars and pedestrians as future changes or developments occur. The vision is to create a welcoming gateway to Northwest Evanston, and this is something that all Evanston residents should be interested in. Mr. Smith also mentioned that making staff's proposed zoning change without an impact or traffic study is not a good idea and deviates from standard map amendment procedures. You've also received lots of comments about drive-throughs. This is because we already have one drive-through that causes traffic snarls and accidents, and there have been several more attempts by businesses wanting drive-throughs over the past 12 years. The staff is now saying that they would never approve a drive-through on any of these parcels. However, they have recommended each drive-through proposal at this intersection. They specifically mentioned in the packet that the Nick's fast food drive-through was infeasible. However, on August 9th, 2017, DAPR made a unanimous recommendation to ZBA for the Nick's drive-through. That drive-through proposal was also revisited in April 2019, where it was still viewed favorably by staff in DAPR meetings. And I have minutes from both of these meetings, too, in case you want to see those. It was withdrawn when the company closed all their locations before it made it to City Council. A drive-through would still need a special use permit, but the threshold for that is much lower and does not give affected property owners the right to formal protests that could require a supermajority approval by City Council. If this change goes ahead, neighbors lose that zoning map protection. In the packet, staff characterizes our neighborhood as not being part of the pedestrian-oriented district of Central Street. However, every resident who lives on the west side of Grosse Pointe must go through this intersection to do anything in Evanston, including shopping at and supporting Evanston businesses. Hundreds of neighbors walk to Lovelace and Bent Parks, to local businesses, to mass transit, and kids use that intersection to go to and from school. It's also heavily used twice a week by clients of Hillside Food Pantry, which is estimated to serve over 1,500 patrons at each event, many of whom take the bus to the south side of the intersection and walk from there. Jeff Smith summed up the history very well in the last paragraph of his statement. The implementation of the overlay district with its specific provisions for Subarea 6 was the result of a comprehensive process that involved 4 separate community workshops, extensive public debate and discussion, the participation of community groups, and collectively hundreds of person evenings, well over 1,000 hours of citizen review and comment, and well-covered discussion within the community and on the city's planning and legislative bodies. What was implemented at the intersection can be seen as the result of nearly 3 years of analysis, planning, and discussion. It was well understood in 2008 that the process of application for variation would allow flexibility in cases of demonstrated need while protecting the rights and safety of citizens. To jettison all that by way of a map amendment without any significant change in circumstances, without any demonstrated need, with no impact studies, without any comparable process, and with no evident driver other than a restaurant with plenty of space wants more outdoor dining, would be counter to Evanston plans, fundamental planning principles, the goals of existing zoning, arbitrary and capricious. Please choose to honor the work and to preserve the vision of what this gateway to Evanston could be. Do not recommend this proposal to Planning and Development and the City Council. Thank you.
Thank you, Ms. Lutz.
Have you received Alderman Suffredin's letter?
I was going to mention, I've had discussions with staff. I've not actually received his letter.
Okay.
And it was our determination together that since we were in the middle of an open hearing,
Okay.
that we would move ahead with our recommendation, and then if Alderman Suffredin decides that he wants to withdraw it or hold it up in P&D or whatever he wants to do, that's his step.
Okay.
But we have our process, and so we're going to see our process through, and then we at least can say we've done what we needed to do. So that's where that netted out. We were aware of his letter.
Okay, great.
Which if it had arrived before we started the hearing would have been different, but since
Right.
we're in the middle of a continuance, it seemed like we should continue through with the
Right.
process.
Okay.
Other questions for Ms. Lutz? Seeing none, thank you.
Thank you.
And then I also have, is it Alan Borman? Who signed up for this? Or no, he just put he just crossed out below, so he didn't list the case, I'm sorry. So it appears Ms. Lutz is our only comment for this one this evening. With that, is there anything city staff would like to say in summation on this case before we close the record and begin our deliberation?
I believe it has all been said at this point.
Thank you. So with that, we will close the record and begin deliberation. Again, this is for a map amendment at the intersection of Grosse Pointe, Crawford, and Central Streets to remove the overlay district for a subsection of that property, of those properties. Thoughts from the board? Commissioner Lindwall?
Sure, I'll start. Couple of things. First of all, that is one of the more difficult, complicated intersections in Evanston, for sure. The only one that I would contend is probably worse is the configuration of Ridge, Green Bay, and Emerson, which is very challenging. And I use both of them very regularly, and I'd much rather be at Central, Grosse Pointe, and Crawford. I have looked at that intersection a lot, and actually the area to the north along Crawford, and I note there are no sidewalks on the east side of Crawford, and I also kind of took a look at kind of where the property lines seem to be with respect to the roadway, and something that I think that the neighbors and the council member Sufferton and maybe Central Street neighbors ought to consider is whether or not, there should be a plan for installing sidewalks. There appears to be plenty of right-of-way, so that, is irrelevant to the subject of this particular hearing, but I think it's important to, mention so that it's on somebody's agenda. With respect to the Central Street plan, it now is 15 years old. And typically with plans, they should be revisited every 10 to 15 years. Just as a rule, we have a comprehensive plan that's 22 years old, and it's overdue for a re-examination as well. And the reason that you want to look at plans is to see what has changed. And since that plan was adopted, we've had a major financial crisis in worldwide financial crisis that really impacted the kinds of development that's likely to occur. Kind of at that period in time, there were several plans. There was the West Evanston plan, the Central Street plan, and the downtown plan, all of which assumed that the pace of development would kind of continue, that there be demand for certain kinds of uses. Obviously the financial crisis changed that dynamic considerably, and until pretty recently, about the only kinds of development that a developer could finance were rental apartment buildings. And subsequently, a couple of the things that were called for at that intersection were, for example, small office buildings and kind of strip center mixed-use development. And given the rise of the internet, that's really not, neither of those uses are particularly viable at the moment. Who knows what the future will bring, and COVID certainly has impacted. So I think that, again, the rationale for removing this these parcels from the overlay was in part to see what could be done to make it easier for existing businesses to make changes in their operations, to do facade improvements and other things that might be, impacted by the overlay district. I mean, if you look at what's allowed, for example, with the overlay, it requires 30-foot setbacks from any major street, whereas the B1 only requires 5 feet. Now, I can see that in setting those setbacks originally, the effect was that any development proposal would have to go through a process, through variations and other things. Whereas with the B1, without the overlay, it may or may not require variation. So I think what I'd like to do before, just to kind of conclude mine is comments, is to really ask Melissa, the zoning administrator, what is the process for variations? Obviously, there's time, there's hearings involved. What kind of extra investment is required of a applicant under the current zoning overlay versus not having the overlay?
With the current overlay regulations, the process for any of these properties, if they were to apply, is that they would first start with a zoning analysis application. Given the very detailed and difficult regulations of the overlay, my expectation is that there would be 3 or 4 or 5 back and forths and site plan adjustments until the property owner could get the plan to the most appropriate possible given the regulations. So that in itself, I would anticipate would take probably a minimum of 60 days and a somewhat decent cost with whatever architect they're working with to update the plans each time. At that point, they would then submit for major variations. And for commercial properties, major variations, the cost is per variation. So anticipating if the properties were not in the overlay, there may be a couple of variations that that these properties would need to apply for given their unique lot shape. But within the overlay, I would anticipate that it would be between 10 and 15 variations requested. So your application fee at that point is into the thousands of dollars. Then the variation process itself typically takes 60 to 90 days. Currently, we're at more like 90 days as we're a little bit backlogged with cases. And that assumes that there are no continuances requested or any other delays in the process. In the end of all of that, altogether, you're probably getting close to 6 months. That's when the applicant would know if their variations are approved or not. After that, they have their permit process and construction.
Okay, thank you.
Excuse me, I think the question was how, you explained how it is now, how it would be now. How would that change if it was, if we took it out of the overlay?
It would largely reduce the back and forth at the beginning with staff and their costs since they would have to revise the site plan less. So it would go
But
probably,
it still would be a special use, right? Most of the time? I mean, I don't-
depending on what is
depending on what it is.
requested. If they needed a special use or variations, I think overall it would take roughly half the amount of time as it would if the properties are still within the overlay. My bigger concern from a land use perspective is that if there are properties applying for 15 variations, something is wrong. And in this case, my belief is that the overlay is what is wrong.
Or the development is wrong.
Correct.
Other commissioners have comments? Commissioner Westerberg?
So if we look at the overlay, it seems to only not work for these transitional properties that are sort of like on the edge and within the traffic, within that very difficult traffic section. Is that correct, or do you feel the overlay in other areas needs to be adjusted as well?
I think the most significant issues are for these properties because they are on the edge of the overlay with multiple busy roads surrounding them. It's not the same type of commercial area that most of the overlay is within. So for most of the properties in the overlay district, properties that are further east, I would not say that the overlay district is always perfect. I mean, it can't be perfect for every property, but most properties can comply with everything or very close to everything. We very rarely see variations within the overlay along those properties.
So I guess that's the question. Is it worse to have everything within the overlay and then have a very long extended process for a couple of properties? Or is it worse to pull them out and then sort of upset that framework that seems to work for the most part? And I really don't know. I'm kind of curious as to how the staff feels about that, whether there really is a need to reevaluate the entire overlay, as Commissioner Lindwall talked about, or whether there is some other way to look at these three properties for relief if they were to choose to make some changes.
I agree that it's always a good idea to review plans once they have hit that 10 or 15 year mark and the world has changed substantially. So I see no harm in reviewing the current overlay regulations and seeing if anything else should change. Off the top of my head, I think the overlay in general is a good thing and is functioning as it should. So I would not anticipate any major changes, but if the commission feels that that is a more appropriate route to take to address these properties that are over by Crawford and Grosse Pointe, that is something that staff can look at.
Commissioner MIRINTCHEV?
I will start a little bit, let's call it from an aerial point of view. I dealt with urban planning for many years, and if you look, let's say, from aerial view on this intersection and how mainly pedestrian flow goes, I would say that one of the most important topics that we should take a look at is how people use this intersection and how they move to some points, let's call it of interest. If you continue Central and continue on Crawford, you have some point of interest on Crawford, including the church, including the pool. Then if you continue on Grosse Pointe Road, you have the park. And this intersection, besides being a really bad intersection, it continues to be bad for pedestrians and bicyclists, because all the bicycle lanes stop at some point of time, of place, I would say, before the intersection. So for me, this is one of the topics that I prefer to keep the overlay instead of removing it, so that we can have really free movement around this intersection of pedestrians. The other thing that bothers me with the change is the reducing the front setback. One typical example is the west wall of CVS. This is it's a bad wall, both visually, aesthetically, and as an attractive place to walk. And in winter, almost nobody walks there, simply because it is full of snow. I live 5 blocks away. I'm very often at this intersection, and I know the problems, and I see how businesses have troubles, and I agree with the zoning administrator on many topics. But I believe that removing these from the overlay is not the solution. I would prefer a better overlay or a better complete solution for this intersection. This is my point. Thank you.
Thank you, Commissioner. Any other? Commissioner Halleck?
Yeah, I agree this intersection needs a lot of help, and hopefully in the future that'll happen. But there's been a lot submitted to us to read, and it's been very educational. Just about the history, why decisions were made, and that's been helpful. Bottom line for me, I do think the setback is one of the biggest issues for safety, as been stated by many of the neighbors. But on this one, I really don't see a good reason to change what we have right now. And I also believe that the neighbors really know the situation better than we do. So I'm going to agree with them on this.
Thank you. Commissioner Johnson, do you have anything, not to put you on the spot, but before I go?
Yeah, I agree with particularly my last two colleagues' comments, and I'm looking at the petition, I'm looking at the public comment, I'm hearing about the problems with this intersection, which I'm a user of as well, not as frequently a user than many in this room, and it doesn't seem like there is a great impetus to recommend approval on this for many of the reasons that we've heard here today and last time.
Thank you. I'll just kind of wrap up here. I am not a fan of overlay districts by any means. I think they create more problems because as someone who's worked as a zoning administrator, or not a zoning administrator, but as a zoning consultant over the years, you often get people who purchase properties and then find out that there's 3 or 4 layers of rules that they must follow each and every time. So I think there are some things here that are problems with this intersection. I would hope that we can find better ways to find solutions than creating overlay districts, and I think that's something that I would throw to Ms. Williams, welcome. I'm going to throw that to you as you begin work on the comprehensive plan, since I believe that's going to be part of your field, and Commissioner Lindwall, you'll be working on that as well. So my request would be, as we begin to do that sort of stuff, let's look at how can we get rid of overlay districts and create straightforward zoning that everyone understands, that you don't have to dig 4 or 5 layers deep sometimes, because if you have an overlay district, you have base zoning, you have a historic district on top of that, and some other little weird thing that's thrown in just for fun.
Except that this is a unique, you have to admit, this is a very unique situation.
This is a unique situation, yes. But this is the first time we've had an overlay district question, so this is the first time I get to put that out there. So that would be a request that I would make as we move forward into this process. I'm inclined to remove the overlay district, but I believe I'm in the minority here, so I'm not going to necessarily belabor anything here. I would ask, though, if there is a commissioner who feels comfortable walking through standards, since I will be doing affirmatives and everyone else will be doing negatives. Or I'm sorry, I will be doing, yes, affirmative standards are met, everyone else will be doing standards are not met. If someone feels comfortable walking through that, if not, I will just go through and everybody can disagree with me each and every time.
Got it. I'd like to make one more if you're done.
I'm done.
Okay. I think it's really important to understand that whatever decision, whatever council decides to do, we're not going to be changing, whether the overlay stays in place or goes away, the traffic is still going to be there. And so we're not, the zoning is not going to change the traffic situation. The real question before us is, and the existing uses are there, and some of them are, more popular than others. And I think that there is an importance in trying to help the existing businesses survive. But the real question is, what happens in some point in the future when somebody comes along and proposes a new development? Because that can impact the future, the access and the easements. I mean, you have driveways that are in a certain place now that people use, and I've parked at Little Island. My preference is to park at CVS and walk across the street, but it's those traffic conditions existed when the plan was done, and whatever we do, they'll exist in the future. So it's really a question of, is our focus on improving, making it easier for existing businesses to do whatever, or are we looking long-term at the future, the unknowable future? That's it.
Thank you, Commissioner Lindwall. So Ms. Jones is going to bring up the standards. I'm happy to go through them if someone does not feel comfortable going through them in the way I think everybody except me is going to vote. Can you blow that up a little bit? Hitting your plus on your keyboard doesn't do it. Usually if you hit like Control plus or something, if not, what I can do is I can read through these, and then I think that might just be easier. Everyone just disagree with me. We have 4 standards that must be met. These are found in section 6345, standards for amendments. The first one, which is A, whether the proposed amendment is consistent with the goals, objectives, and policies of the comprehensive general plan as adopted and amended from time to time by City Council. I feel this standard is met because often we are looking at ways to allow existing businesses and develop properties ways to improve themselves, and I feel that this overlay district in this particular case prevents the businesses that are there from being able to make even modest changes to their properties.
But I'll disagree on this. You want a disagreement, right?
I think
No, I'll disagree because I think that again, reading all the history that went into the reason why it is right now says that there was a lot of thought put into this area when it was part of the original comprehensive plan. And so I would say that, no, it's not consistent. The change is not consistent with the current plan.
Yeah, and just to kind of piggyback on that a little bit, we have the, the overlay district that was adopted by the city council, and while, I think that maybe change could be considered, and I agree with you, but the, overlay districts are not a good idea generally if you can avoid them, that there needs to be a more thoughtful planning process as to how the overlay district should change.
Thank you. B is whether the proposed amendment is compatible with the overall character of the existing development in the immediate vicinity of the subject property. In this particular property, we have what is a transition between residential and commercial. And so I do think that we have to look at how does that transition play? And I think that, again, allowing some more of a transition between the 30-foot setbacks to the from the residential setbacks to the 30-foot setbacks that are in the remainder of the overlay district. To me, it makes sense to have some sort of a transition there to help differentiate those two areas. But I know I'm in the minority once again.
Well, no, I think actually I will agree with that standard is met because the current zoning really, I don't think we've had evidence that any of the existing uses couldn't exist within the B1A zoning district. So I think that, in the setbacks that are currently there are probably more consistent with the underlying zoning than they are with the overlay district.
C, whether the proposed amendment will have an adverse effect on the value of adjacent properties. I believe this standard is met. I do believe that by allowing these businesses to make necessary facade improvements, extensions, expansions, things like that, that it actually would have an increase on making the neighborhood nicer, and therefore bringing up surrounding property values. If not for the residential properties themselves, I don't see it as being detrimental, but I see it as an increase, at least for the commercial properties, if nothing else.
And I would disagree here only because I think the question is long-term. What happens when there's a different kind of development that wants to go in, or a change in, whether it's a drive-through facility or a great change in the facade or what the business is doing. Again, I think some changes can be accommodated, but there are others that can have an effect on traffic, on the nature between pedestrian and car traffic. And I think that presents a problem for the adjacent properties in terms of what their neighborhood is really like.
All right. And the last one is the adequacy of public facilities and services. I don't think that there's, obviously the properties that exist with their public services, with their utilities, things like that. And so I believe that standard is met as well. Anyone disagree? Normally I ask if everyone's in agreement with my standards, but I know most people aren't. I will go ahead and make the motion, since mine will be a motion in the affirmative, which is what we usually try to do. So give me a second here. So in the matter 22 PLND 0038, a map amendment rezoning properties on Grosse Pointe Road, Crawford Avenue and Central Street in what is known as the subsection 6 of the overlay district for Central Street corridor. I would move that we recommend approval to City Council with the condition, I'm just going to throw this in so they become aware of it, that the city begin a study looking at evaluation for increasing sidewalks along that area to improve pedestrian travel through that particularly difficult intersection. as well as that it be in compliance with the discussion that we've had this evening and at our last meeting. Is there a second?
I'll second.
So it's been moved by Rogers, seconded by Lindwall. Is there any further discussion? Hearing none, would you take a roll call, please?
Commissioner Halleck? Commissioner Westerberg?
No.
Commissioner MIRINTCHEV?
No.
Commissioner Johnson? No. Commissioner Lindwall?
No.
And Chair Rogers?
Yes. So with a vote of 1 to 5, the motion fails. So it will go forward with a recommendation for denial to City Council. So that will move on to, I'm trying to find Ms. Lutz back there, who seems to be the only one, I think, kind of here for this. So that will move on to P&D, Planning and Development for City Council, and then Alderman Suffredin will do whatever he decides to do with it at that particular point. All right.
July 25th.
All right. Thank you for coming out. And then your petition you have with the city clerk, so you'll figure all of that out as well. All right. Thank you. We will move on to our second piece of business that we'll be hearing this evening, which is a text amendment for billboards. To give a little background here, we have discussed this a couple times before. It moved on to Planning and Development at City Council. There was some discussion, and they decided to refer it back to us. Do you want to read it into the record, or do you want me just to do my thing?
Into the record.
Okay, if you'd read it into the record, please.
Text amendment for billboards, 22 PLND 0042. City-initiated text amendment to the zoning ordinance, Title VI of the City Code, to establish regulations to allow billboards in all zoning districts. The Land Use Commission makes a recommendation to the City Council, the determining body for this case, in accordance with Section 634 of the Evanston Zoning Ordinance and Ordinance 92021.
Thank you, Ms. Klotz. At this point, I have a statement to read. Exercising the authority and powers granted under Article 10 of the Rules and Procedures of the Land Use Commission for the City of Evanston, the chair has determined that this case presents no new evidence or testimony that was not available at the time of previous hearings. The initial public hearing determined that billboards anywhere within the City of Evanston would be contrary to the character of the city and its adopted comprehensive general plan. The Planning and Development Committee of City Council has not provided any new issues for us to discuss. Therefore, without objection, the Land Use Commission returns 22 PLND 0042 regarding billboards for a text amendment to the Planning and Development Committee, and its original unanimous recommendation for denial of billboards throughout the City of Evanston stands.
I think I disagree with one thing you said, which was that you said that no new information was added. But I think I read that it was discussed as an option to put billboards only along the railroad tracks and to face them toward the railroad tracks. That was new, I think.
So I have no one here to present that new information to me.
Okay.
And we can't add that to our one way or the other. Our thoughts on this.
So basically, the rules allow the chair to make a determination whether or not there is significant change from a proposal that has come before us before. If you feel that there is a significant change, then in my statement I say without objection, and you would have to object to it, and then we would have to have it. Then we would take a vote. A hearing would be held on it.
Can't I just add a footnote here?
To clarify for the commission, when this was discussed in the last public hearing, there was, I did specifically bring up after the very unanimous no billboards, I said, is there an appetite for it only in certain locations, perhaps along train lines? It was a very quick discussion, but it was had. So if you feel that we should discuss it more, then please do. But it was briefly talked about.
I just want our recommendation to include that I assume we don't, just to be clear about what we decided that day, that we don't think it's a good idea to line I don't think it's a good idea to line the railroad tracks with billboards.
Our recommendation was that they not be anywhere in the city of Evanston.
Okay. All right.
And that would include along CTA metro lines.
I would support the chair's statement.
I would too, but I also would like to say I actually watched the whole P&D meeting, so I saw the discussion of the proposal, for a billboard not facing the street, not visible from the street, facing the tracks. But the other thing that Councilmember Sufferton raised was the possibility of having basically off-premises advertising on public buildings, which I don't know if that constitutes a billboard or an off-premises sign or some other thing. I think there seemed to be some different, I'm not sure that what he was talking about necessarily was a billboard.
But the problem is, while the media may change, the issue is
It's
still
the signage.
advertising in very, very large areas
Right.
aimed at.
And-
And I think, at least the last time we discussed this, we said that unanimously this was not in character with the city of Evanston.
And they're just, and I think we stated the reasons why it's a bad idea, so.
I do have a question, though. I don't know if you could answer this. Anyone could answer this, but is the question that the council will resolve whether or not we have any billboards, in other words, retroactively on the billboards that are there, or is just any new billboards, or not? Are the existing billboards part of the question, part of the decision?
No, existing billboards are considered legally non-conforming, so they may continue to exist regardless of what happens with this text amendment.
I see.
I mean, my feeling on this is city council can decide whatever city council wants. We don't have anyone here arguing one way or the other for this particular case. So for us to hold a whole new hearing on it doesn't make sense. That's why I just want to refer it back to them with the fact that our original unanimous recommendation for denial of billboards stands. All right. As I mentioned before, the last case that we were to hear tonight has been continued. So we'll move on to communication.
Do we need to make a motion to continue that, or just that?
Yes, we do. I'm sorry. Is there a motion to continue PLND 22 PLND 0010 2044 Wesley Avenue to our September 28th meeting?
So moved.
Moved by Lindwall. Is there a second?
I'll second.
Seconded by Westerberg. Any further discussion? Hearing none. Would you take a roll call vote, please?
Commissioner Halleck? Yes. Commissioner Westerberg?
Yes.
Commissioner MIRINTCHEV?
Yes.
Commissioner Johnson? Yes. Commissioner Lindwall?
Yes.
And Chair Rogers?
Yes, with a vote of 6-0. The matter is continued till our September 28th meeting, at which time we will hear it.
Chair Rogers,
Yes.
I'm sorry. Do we need to vote on your statement
No.
about the
No, so the
Billboards.
authority on our rules is granted to the chair in consultation with
Okay.
the zoning administrator. So
Yeah,
only
just
if you-
wanted to
only if you
support
obje-
it.
Only if you object to it.
I
would you
wanted
need to
you
take
to
a vote?
know that you have our support.
Thank you. We move on to communication. Anything from staff?
No new communication.
Public comment. We do have a section at the end for public comment. If there's anybody here who would like to address this board on any matter, whether it was on the agenda this evening or not, they may do so at this time. Yes, please come up to the lectern, and if you would state your name and address for the record, please.
Hi, my name is Betty Bogg, and I work at an office at 2121 Dewey in Evanston. I'm the Executive Director of Connections for the Homeless, and I'm here tonight to give a brief update on the status of our application for a special use permit for the Margarita Inn. On May 25th, at the May 25th Commission meeting, our legal representative stated that we would submit our application within 2 weeks. Clearly, that has not happened as we had hoped it would. The reason for this is because in order to submit the application, we must have the owner of the Margarita Inn signature on that application, which he has thus far declined to grant in the absence of a finalized letter of intent or purchase agreement. I can report that we are making good progress and are close to finalizing an agreement, and once that agreement is signed, we will submit our SUP application as quickly as we can and in accordance with guidance provided to us by city staff. Thank you for your patience. We are eager to submit our application and to have the process move forward.
Thank you, Ms. Bogg. Yes, I've been talking with staff and aldermen behind the scenes, so I'm kind of aware of what's going on. And so we are aware of the situation. I know there are several moving parts to this, both at the city and between you and the owner of the property. So thank you, though, for the update. We appreciate it. Any other public comment this evening? Hearing none, is there a motion to adjourn?
I'll move to adjourn.
I'll second.
It's been moved and seconded. Is there any discussion? Hearing none, all in favor, please say aye.
Aye.
Aye. With that, this body does stand adjourned until our meeting on Wednesday, July 27th at 7 p.m. in council chambers. Thank you, everyone.